Hi, good morning. Thank you all for joining us today for our free webinar, To Trust or Not to Trust, Should You Have a Trust? For those of you joining us for the first time, my name is Amanda Sylvia, and I am the Client Service Associate for Stonehearth. I have been with the firm for about 3.5 years now, and my primary role includes client service, marketing, and compliance. I just want to start off with a few housekeeping items. On your GoToMeeting taskbar, you should see a section titled Questions. Please feel free to submit any questions throughout the course of the webinar. I personally will be monitoring all the questions and will ask Jamie to answer as many as time allows at the end of the webinar. If we do happen to run low on time and we are unable to get to your question, Jamie or myself will reach out to you directly to make sure we get your question answered. Now I would like to introduce our speaker for today. Jamie Upson is Stonehearth's President and CEO. He has been with the firm since 2000, and in the first couple of years here, he focused mostly on portfolio management, design, strategy, and product analysis. In 2006, Jamie passed the CFP exam and spent the next 11 years at Stonehearth co-managing client portfolios and building, analyzing, and monitoring client financial plans. In 2017, Jamie purchased the firm, and he hopes to lead the firm forward and continue to help our clients meet their financial goals. Jamie, thank you so much for joining us today.
Absolutely. Good morning, everyone. And thank you, Amanda. Special thanks to Amanda because she always helps put together this material. Without her, I would not be able to have these slides look as clean as they are and help to get the message across. So again, thank you, Amanda. So again, good morning, everyone. Today's topic is to trust or not to trust. And really the idea is to get the point across of what is a trust, how do you use them, what are they used for, and most importantly, is it something that you should consider having? So today, let's go through a couple line items. And I apologize, but this is the second time that my Microsoft PowerPoint has shut down. So bear with me just for 1 second. And let me just load this up one more time. Hopefully that will solve the problem. All right, we'll try it again. All right, fingers crossed that it stays up. All right, so what we'll discuss today is what is a trust, why someone would want to create a trust. We're going to talk about the differences between irrevocable trusts and revocable trusts. Is a trust right for you, which I think is the primary point of this conversation. I want to spend a little bit of time focusing on estate taxes. Our home state is Massachusetts, and there are some particular estate planning issues that surface for those people that treat their primary residence and live in Massachusetts. And also when we discuss when it's appropriate for somebody to incorporate a trust, it's also important that we address when you should pass on creating a trust. So let's just dive right in. Oh boy, it's still doing it. All right, so I'm going to try one other workaround. I'm going to try to do it not in presentation mode. This is actually the first time this has happened. So again, I apologize about this. So it'll look a little bit different, and hopefully you can still see the screen well enough. So let's talk about what is a trust. A trust is an agreement that you put in writing that describes how you want assets managed and how they should be distributed. There's a couple of parties that come into play when you're dealing with trusts. First and foremost, you have the person that is creating the trust. Just as you would expect in the legal world, there are multiple words that you can use to define this or to reference the same individual. And again, I think they do this just to keep us confused. Mission accomplished. Creator, settler, grantor, trustor, these are all the same party. And again, you'll read it, you'll have 5 different attorneys write articles about it, and 5 different times you might see them using different languages throughout the trust, and many times it makes it just harder to read because we don't know what they're talking about with many of these things. So you've got the creator, the person that creates the trust. You've got the trustee, who is the party that's going to administer the trust. They're the ones that are managing the trust on a day-to-day basis. They're the ones that are responsible to have the tax reporting done, communicate with the beneficiaries, and to follow the terms of the trust. And then finally, you have the beneficiaries, and those are the people that either receive a benefit today or they will receive a benefit tomorrow or when somebody passes away. So again, it's an agreement, it's done in writing, and there are 3 parties that are included within a trust document. Now, just because I say 3 parties, just recognize that you can have the same person who fulfills all 3 of those parties. The same person, if I wanted to create a trust, I could also appoint myself as trustee, and I could also appoint myself as beneficiary. And for at least revocable trusts, that is the most common arrangement. You then typically name successor trustees, which are individuals that are next in line to serve as trustee, as you would also do with beneficiaries. So you can have primary beneficiaries, secondary beneficiaries, and so on. Another thing to mention is that trustees, they do not have to be people. They could be corporations. So there are a whole slew of corporate trustees out there. We have a couple at our disposal, so that if somebody cannot identify an individual that they trust to be to fulfill the roles of a trustee, then we can go out and hire a corporation that's what they do for a living. And many of these corporations, that's their sole responsibility. They act as fiduciaries, and they've been doing this for a long time. And with beneficiaries, we also naturally think of individuals, but you can also have charities, organizations, or corporations named as one or one of many beneficiaries. Good news so far. So PowerPoint hasn't crashed on us yet. All right, so we're going to continue on what is a trust. One of the things that you need to do is once you create the trust, and this is where a lot of people go astray, they forget or didn't know that they needed to do this. I think attorneys have done a better job of addressing this, but it's all centered around the idea of funding a trust. A lot of the attorneys that are drafting these trusts are now scheduling appointments with financial advisors and the client, the mutual client, so that they actually talk to us about funding the trust. I think that's a huge step in the right direction, because years ago there were some stats, scary stats, that 30 to 40% of the time that people created trusts, they never put assets into the trust. It's important to know that in order for the trust to really flex its muscles and to utilize some of the benefits that come along with trust, you need to fund them. You need to put assets that you want to be controlled by the trust into the trust, and we call that funding. Now, you can do funding inter vivos, or you can also do it as more or less like a testamentary trust, and I reference these 2 here. Inter vivos is really you create a trust and you fund it while you're alive. So if I want to create a trust and I want to put my house into the trust, I do that. I go over to the Salem Registry of Deeds and I retitle, and I tell them that I want to transfer my title to the property over to my trust. That is a funded trust now. I want to change my bank accounts to a trust. I go to the bank and I show them a certificate of trustee document, which is a brief version of the trust document, and they will use that information to help me change the title of ownership from maybe a personal account or a joint account into the trust that I had created. That is now funding the trust, and that is a very, very important process. It is important that you try to identify which assets should be funded into the trust and which assets cannot be funded into the trust. This would go into a little bit too much technical detail, but for all intents and purposes, you really want to talk to the attorney and ask the attorney, please help me identify which assets I should be retitling. And they either ask for their help in retitling, or you should address the retitling yourself. When it comes to unfunded, there are a lot of trusts that are unfunded, and they're supposed to be unfunded. They're usually funded when somebody passes away. So for example, if I have a will, and in my will, I want my children to receive assets, but I don't want them to get the money at 18 or 21 years of age. I want them to get the money when they're 30. What I do is in my will, I create a paragraph or a section that says, upon my death, I would like a testamentary trust, that's just a trust to be created later on, And then I want to identify which assets I want to go into that trust. You also identify the three parties. I would be the creator, but the trustee is maybe my sister or my wife or my parents to manage the assets for my children until they hit an older age, when I believe that they'll be better able to handle the inheritance. So again, that's unfunded. Some trusts are designed to be unfunded, and we typically see those set up as what's called testamentary trusts. So there are three primary reasons why people create trusts. I think the number one reason that most people recognize is to avoid probate. Probate has a nasty stigma to it. I think it's gotten better, particularly here in Massachusetts, where it's not as hard as it used to be, but it's still labor intensive. There's still a lot of needs. You need a lot of help from attorneys. There's a lot of filings that need to be done. Another issue is that it's a public process, so any of your assets that you have will be disclosed to the public. So if that's a concern of yours, then creating a trust is particularly important. The second reason that most attorneys will recognize is to identify a secondary trustee. So in the document, again, the trust document is really designed to be self-sufficient. So within that trust document, you identify who's going to take over as trustee if I had to step down because I was sick. And then the final reason is that I list here is sort of a joke, but in many respects, it's a response that I hear many often is because the attorney suggested it. I'm not really sure why I have a trust. Maybe at that time they knew why, and I'm sure the attorney, or I presume the attorney, did a good job of describing what it is. But a lot of this stuff is technical and not necessarily an area that many of us specialize in. So we trust the attorney, and we feel that the attorney was doing their job and acting in our best interest, and so they recommended that we do it, and so we did it. We followed their advice. The number one reason, though, by far, that most people will reference is probate, followed by the secondary trustee for what we call incapacitation issues. There is another one that I'll just briefly reference, and you'll see it on the next slide anyways, and that's privacy. This is I'm not surprised, but it's always interesting to read these things to me. Aretha Franklin, who recently passed away, many of you might have actually also read this note, that her estate is estimated to be around $80 million. We will end up finding out how large her estate is because she did not incorporate a trust. And we also found out that she did not incorporate a will. So they call this intestacy. And this means that there's no will, there's no trust. We're going to use the courts or that state's legal system to determine who's going to ultimately be the beneficiaries. And so when you see this, especially with celebrities or people that have a lot of wealth, you end up seeing lots of legal battles because somebody feels that they were cheated. Somebody felt like that Aretha Franklin probably wanted them to receive part of her estate. So this is where the legal battles will go on. So this is why it's super important that, if you have assets that you want to distribute in a particular manner, that you need to document that. And a will obviously does that, and a trust has does that as well, but it also has a couple other bells and whistles that you may or may not be interested in. So let's take a closer look at revocable trusts. As I referenced, there are really two types of trusts that you can create. Revocable trusts are ones that can be modified. All trusts are private, whether it's revocable or irrevocable. One thing that I want to point out, and I cannot stress this enough because I think this is very misleading for a lot of people, when they hear the word trust, they automatically think that their assets are protected from a creditors or a nursing home. I wish it were that easy, but most people create revocable trusts, and revocable trusts do not offer asset protection. If you don't know, or if you have questions whether your estate plan, whether your trust does offer asset protection from creditors or nursing homes, I usually suggest that you ask a couple of questions. The ultimate answer is go see the attorney that drafted it and ask that question, and they will tell you yes or no. That's the best response. The next one that you could sort of get to, you could arrive at your answer, is look in your trust and see if you have any abilities to modify the trust. If you have the ability to change the terms, the whole idea of asset protection is to separate those assets from assets that you control. And the whole idea is that if you don't control those assets, then how could somebody like a creditor or a nursing home force you to turn those assets over to them to pay for your care or cover your debts? So if you have successfully created an irrevocable trust, or sometimes called an irrevocable, everybody uses the term, it's the same thing, but people pronounce it differently. If you use the irrevocable or irrevocable trusts, many times that does create a barrier between you and those assets, and you don't have the ability to modify it. And in the document, they say that you can't use it for, to cover debts or to cover nursing home expenses. And so they can't force you to do that. So that's something that I consistently find, that people feel like they have that protection, when in reality, I always question whether they really have that. If they show me their trusts, I can identify it. Or again, the best answer is to go see the attorney and just ask them, is my trust set up so that I can protect the assets in the trust that I've already funded? Can I protect it from creditors and or nursing homes? In theory, you could substitute your will with the trust. Again, you want everything that can be owned by the trust. Usually you want it to be owned. Your attorney will typically say, any of these assets, go ahead and put those and fund them into the trust. The will is usually a catch-all. It catches anything that you couldn't put into the trust or you forgot to put into the trust. And quite often that happens a lot. They're usually small stock certificates or a bank account that you had to open up for free checking and it's got $100 in it. Well, the problem is when you pass away, if there are no named beneficiaries or a joint owner, that's going to need to be probated. So again, even small accounts, if you really want to avoid probate, then you really want to make sure that you put those assets into the trust. So in theory, you could substitute, the trust could substitute your will, but in practice, I find that you still need a will, and most attorneys still create a will for you, even if they're going to create a trust for you as well. People that want to retain control of assets in the trust, again, in my earlier example, if I put assets into the trust, I'm the trustee and I'm the beneficiary, well then that, I'm not really changing a whole lot of things here, but yet I can meet certain criteria that I have, like what if I'm a celebrity and I want to keep things private? Well, I can do that while still retaining control of the assets in the trust. As I mentioned, the creator is usually the trustee and the primary beneficiary. Income taxes is relatively straightforward. You just report any tax liability for anything that's held within the trust. You just report it on your tax return, your typical 1040 tax return. So the taxes are very clean. You open up these types of accounts with your own social security number. So it's a rather clean process, and we have a lot of families that use revocable trusts, and they are very common within estate planning practices to help families create an estate plan, and they typically do use revocable trust for that. One thing to point out is at the creator's death, the trust does become irrevocable. So again, as I set up above, you can modify this trust until you pass away, at which time everything's locked in. The trust becomes irrevocable. A new trustee is appointed who is then chartered with the task of following the terms of the trust. And hopefully the trust was well drafted, so there's no misunderstanding, so that the trustee can follow what those terms are that you indicated and put down in writing. All right, let's switch over to irrevocable trusts. Some of the highlights here, they are considered a separate entity. Again, you want to create that barrier between your own financial affairs and assets and those of the trust. In order to do that, you really need to pursue irrevocable trusts. They also are private. So again, it's Aretha Franklin. If she knew she was going to pass away, or I guess maybe she did because there was an illness there. But you know, I actually read in some of the write-ups about her scenario that her attorney did recommend that she created a trust. She just never agreed to do it. But if she had, we would not know what the actual assets are that she had and that she passed away with. But because she did not have the trust, it's going to be public record, and you bet people are going to start reporting on that. Irrevocable trusts may offer asset protection from creditors or nursing home. I say may because not all irrevocable trusts are designed to protect assets from creditors or nursing homes. Sometimes there's another reason that you're creating the irrevocable trust. But if you're trying to do it for protection, asset protection strategies, then yeah, irrevocable trusts are the common solution for that objective, and you know, they work. There's always tests, there's always groups that are trying to say that this trust does not work because. So the attorneys will tell you right at the beginning that, you know, we've seen that this is a good solution in the past to protect assets from creditors or a nursing home, but there's no guarantee that the rules aren't going to change and that they can start to go after those kind of trusts. Taxes with trusts, irrevocable trusts, can be rather complex. When you're dealing with assets that are held in all trusts, you're typically dealing with interest, dividends, and capital gains, and somebody needs to pick up the tax liability. Now, when you look at tax brackets, which I'm going to show you in a second, you'll see very clearly that from a tax point of view, it always makes sense to have people pick up the tax liability and not to have a trust pick up the tax liability. But the challenge is, if you're dealing with a separate entity, that entity is charged with, it's responsible to pick up its own tax liability. You almost need to think of an irrevocable trust as its own entity, its own living and breathing person. But if the trust starts distributing income to individuals or beneficiaries, then it is possible in most instances to have the taxes for whatever generated that income that we're sending to those beneficiaries. It is possible to push that income out to that beneficiary so that they pick it up on their tax return. Again, well, actually, why not just show you while I'm addressing this. So here's a picture of the 2018 tax brackets. Here we've got married filing jointly, here we've got singles, and here we have estates and trusts. So what I want to just point out to you here is that if you're fortunate enough to make $600,000 or you have $600,000 of taxable income or greater, then you fall within the 37% tax bracket, which means 37 cents of every dollar is going to go to federal income taxes. This has nothing to do with state taxes. Here, if you're a single person, you hit that 37% tax bracket if you make $500,000 or generate $500,000 of taxable income. But take a look at trusts. Trust, if you generate $12,500 of taxable income, you've already hit the 37% tax bracket. So you can see why you would want individuals, which are the top two brackets here, categories. You can see why individuals, it's more advantageous for them to pick up the tax liability versus having the trust pick up the tax liability. So in most instances where you're paying out income to beneficiaries, the accountants just issue what's called a K-1. It's just a tax form that the trustee hands to the beneficiary and says, hey, by the way, we sent you $10,000 this year, and likewise, you're going to pick up the tax liability for that $10,000 on your own tax return, and here's the K-1 that you will use to do that. If in the event you do not distribute assets, then more than likely the trust is going to pick up the tax liability, and depending upon how much income or interest is embedded or earned, then you're going to find out what tax bracket you fall within. Let me go back a slide just for a second. You must file your own tax return and pay their own taxes, as I said, exceptions apply. Really, that's when you're starting to distribute income to income beneficiaries. And then an important, super important distinguishing factor is that irrevocable trusts cannot be modified. That scares a lot of people, especially when you're telling them that you need to create, when you do create an irrevocable trust, you're creating a barrier between you and that money or those assets now. Things that you owned, you no longer own and have access to. And in most instances, in many instances, somebody else is the trustee and they're following the terms of those trusts. Again, there's a whole bunch of reasons why people would want to create irrevocable trusts, but for people that are not super concerned about asset protection, they put greater emphasis on keeping assets in their own name or their own trust so that they have access to them. That's when you would see revocable trusts or revocable trusts being the more common solution. But irrevocable trusts can and do play an important role when the objectives are spot on for the benefits that you get from an irrevocable trust. So let's focus on, is a trust right for you? And really what I'm talking about is any kind of trust. And first and foremost, probate. Anything that's in trust, whether it's revocable or irrevocable, they all avoid probate. If you want to control assets from the grave, trusts are sort of crucial. I'm not sure if you could even do that through the use of just a will. Because if I pass away and I want to leave a legacy for my family and I want everybody to go to St. Anselm College, I can specify that my grandkids will only get to take money out of the trust if they go to St. Anselm College and if they get an average GPA of whatever. So you can be very specific within trust documents. Many attorneys will suggest that you keep things a little bit more flexible, but you do have the autonomy, you do have the ability to create as many restrictions and as many hurdles that you feel are necessary to meet your objectives. If you want privacy, again, trusts are huge for that, and there's not a lot of other good solutions for maintaining privacy when it comes to when you pass, keeping all your financial affairs private. If you have property, and I'm really talking about real estate in more than one state, then you typically want to look at trusts. And the reason for that is if you don't, then you need to probate, you potentially need to probate assets in more than one state. I mean, probate is not something that people want to do, it's something that they have to do. And to have to do that in more than one state because you have another property that's in New Hampshire, well, maybe that's not your intention, and it might make sense to create a trust. They usually call these realty trusts that will own real estate. So you would, if you've got a second home in New Hampshire, you create this realty trust, and you then change the deed in New Hampshire to that realty trust. And if and when you pass away, there's a named beneficiary, and that's really what the states are looking for. That's the whole process is there. That's probate is trying to identify who are the beneficiaries, who are the people that should be receiving this money or these assets. Well, the trust document does that for you without going through that probate process. So this is sort of a slam dunk when you hear of people with multiple properties in more than one state. If you have a more colorful family dynamic, second marriages, children from a prior marriage, these are classic cases of where you should give consideration to trusts. For example, if my wife and I had children, we then divorce and I remarry, if I want my new spouse to have access to money if I passed away during her lifetime, but ultimately when she passes away, I want my original children that I had with my first spouse to receive the remaining assets, then they'll put together what's called a QTip trust. And they are common, we see them a lot, they are effective, and they're irrevocable. When you initiate, once somebody passes away and assets are now available for the new spouse can gain access to those assets, but she can't change the beneficiaries. He or she cannot change the beneficiaries for who will ultimately receive those assets. If you have minor children, I gave that example at the beginning of the call, so that you can have somebody control assets until you believe your children are mature enough to inherit and handle that money. And then finally, if you want to leave accounts or assets to someone with special needs, one of the challenges with special needs is that if they qualify for government benefits, the government benefit program is dependent upon assets. And so if you leave assets to them, you could disqualify them from receiving government benefits. And so one of the ways around that is to leave your assets for that person to what's called a special needs trust, so that there's a trustee, that person with special needs has access to that trust, but those assets in the trust are not considered assets of that special needs person, so that when they're filling out the government benefits application, they do not need to disclose that they own assets or have access to assets in a special needs trust. So that's something that needs to be considered, and one of the reasons why many attorneys will say, are you leaving any money to anybody that has special needs who may in the future or currently receiving government benefits? And the reason they're asking for that is they want to know whether they should consider putting together a special needs trust for you. I'm going to spend a little bit more time on state taxes. So we're about 30 minutes in, so I think we're making good progress here. Estate taxes, because we live in Massachusetts, we have death taxes here in Massachusetts, otherwise known as estate taxes. When you pass assets on to a non-spouse beneficiary. An important distinction, though, is that if I pass away and I have $1 billion, I could pass that to my spouse, and my spouse does not owe estate taxes yet. When my spouse passes away, that's when he or she would end up owing estate taxes. Well, Massachusetts happens to be one of the states that does charge estate taxes. In Massachusetts, the exclusion amount is $1 million. So if you have assets that exceed $1 million, and you got to also include your life insurance in most instances in this math. You don't if your life insurance is owned by an irrevocable life insurance trust, but that complicates things. Most people own their life insurance themselves, in which case we need to include the life insurance in this threshold of $1 million. If you exceed $1 million, then you know what, you probably would benefit by using some trusts that will help to reduce the estate tax exposure. One of the things that a lot of people don't know is when somebody passes away, if it's the second spouse that passes away, an estate tax return needs to be filed, and on the box it says, is your estate greater or less than $1 million? That's really all they're using it for so far, is just to determine whether you should be subject to estate taxes or not. And if the answer is that you're under $1 million, it's okay, you're all done. You don't need to worry about paying any estate taxes. If your assets are greater than $1 million, even if it's $1,001,001, then you need to check the box yes, and then the full $1,001,001 is subject to estate taxes. You did not mishear that or misunderstand it. So again, the 1 million is just the triggering point to tell you whether you do need to go forward or whether you can stop. If you do need to go forward, then you are going to end up owing some kind of estate tax, and they're going to tax everything you own, including the first $1 million. So what is one of the solutions that can eliminate it? But usually it depends on how much your surviving spouse's net worth is when they pass away. The larger the estate, the less of an impact these estate tax sensitive trusts are going to have. But for people that have, say, 1 to 3 million or 5 million, percentage wise, these estate tax sensitive trusts can shelter a lot of money, and they are very common. They've been around, I believe, since the 70s. Again, a lot of states have done away with estate taxes, and the federal government, as I list down below, now the exemption amount is $11 million per person, or $22 million combined. There's all these new rules with portability as well that make a lot of the old planning still valid if you want certain asset protection strategies incorporated in them. But when it comes to estate taxes, these estate tax sensitive trusts in most states are not as important as they were before. Now in Massachusetts, just to be clear, because we still have a death tax, the old estate plans that address estate tax sensitivity are still valid and still commonly used by attorneys in Massachusetts. But if you live in other states, especially states that don't have an estate tax, and you have less than $11 million of a net worth or an estate, then you might want to revisit this your trust with your attorney, because it may be that you don't need those trusts, or that your estate plan needs to be adjusted going forward, because when they were set up, some of the rules have changed. And this always warrants the need to revisit things with attorneys. We suggest that people over the age of 65 meet with their attorney every 3 to 5 years just to have a visit and review the terms of your estate plan and make sure that it's current with the current rules. Let's focus on when you should pass on creating a trust. So first, if you don't have assets to put into a trust, then why create a trust? You wouldn't. You don't want to spend money to create a trust. Most trusts are going to cost anywhere from $1,500 to $5,000 just to create your run-of-the-mill types of trusts. The estate tax sensitive trusts that I've been referencing to help reduce mass estate taxes, they usually run about $3,500 to $5,000, maybe a little bit more. It all depends on the attorney and the complexity. If you want more complexity, then just increase these costs because it's going to take an attorney longer to draft these documents and help identify how they should be drafted and the solutions and the challenges for meeting a more complicated scenario. But your run-of-the-mill is about $3,500 to $5,000 for a family to have a estate tax sensitive trust in Massachusetts. Again, if you live in a different state like New Hampshire, maybe you don't need those estate tax sensitive trusts, and maybe all you need are simple sweetheart wills that leave everything to each other and then the kids. If you are okay, if your estate is probated, I sometimes hear that. Sometimes people they're not that concerned. They hear that the estate probate process has been a little bit more streamlined in the past, and that they feel that it's not as big of a hurdle, and why spend the money to create the trusts. And I've also heard people say, I'm not going to be here, so it's not going to impact them. Privacy, if privacy is not important to you, we're not all celebrities, and so if we're not concerned about somebody snooping and trying to find out what assets we own, then privacy might not be a determining factor or criteria for you. Then maybe you don't need a trust. If you already have durable power of attorneys, now most attorneys will put together durable power of attorneys for you, but one of the values of having a trust is that if you became incapacitated, the trust document, remember it's self-fulfilling document, it already identifies who will step in place to handle the affairs of the trust. Many people will also have a durable power of attorney to handle everything that's not owned by the trust. So just to be clear, when you have a trust document and you also have durable power of attorneys, you don't look at the durable power of attorney to determine who's going to step in line as the new trustee. You look at the trust document to determine if I became sick or I needed to step down acting as trustee, who would step in on my behalf. The trust document does that. But if I don't have a trust, there are other documents that can also take care and address incapacitation, and we call those durable power of attorneys, typically for finances. If you're not concerned about estate taxes, I've heard that a couple of times, not that often. As soon as you start to talk to people about how large the estate tax can be, they're usually more eager and willing to start exploring either gifting strategies, clearly putting together estate tax sensitive trusts, et cetera, et cetera. If you'd prefer to keep your estate plan simple. Now, I've seen trusts that have absolutely simplified people's estate plans, but I've also seen estate plans that incorporate trusts that have just made things just a mess. It just added so much complexity where it wasn't necessary. Again, we create these documents with the knowledge that we have today. If we knew how things were going to play out tomorrow, then we might do things differently. But again, with the knowledge that we have today, you either decide that trusts are relevant or they're not. And if they are relevant, you put in the terms that of how you want things to play out, but you don't know if your child is going to get divorced. You don't know if they're going to have a drug addiction. This is why a lot of people will incorporate trusts to try to shelter those assets from their children getting divorced, their children if they're experiencing drug or alcohol or gambling issues. Again, with the knowledge that we have today, you need to make a determination of whether the trust is something that you want to pursue or not. It usually does add some complexity to it. So it usually doesn't simplify things as much as people would want you to believe. Most of your assets are jointly owned or you have listed beneficiaries. And I referenced that both of these avoid probate. So if the number one reason that people create trusts is to avoid probate, well, you can also avoid probate if you just own everything jointly with somebody, usually your spouse, or you list beneficiaries for your life insurance and your retirement accounts. So already, most married couples are going to avoid probate. Even for unmarried single people, we also name beneficiaries on all the assets that we control. At TD Ameritrade, we always encourage people to name beneficiaries so that we can avoid probate. So you don't have to have a trust, but a trust does help avoid probate, just like naming beneficiaries or owning things jointly would avoid probate. If most of your assets are owned within a retirement account, well, just remember that if you have an old 401k, which is now in an IRA account, and that's most of your assets, well, you can't put retirement assets into a trust while you're living. You can at death by naming a trust as a beneficiary, but while you're living, the only way that you can get money into a trust is to liquidate the IRA. Most likely you're going to owe a boatload of taxes, and then you take the net proceeds after paying taxes and put that into a trust. So if I have $1 million IRA and I close it out, I'm going to pay taxes at 37%. I'm going to have, roughly $600,000 that I'm going to be able to then go ahead and put into a trust. You see people willing to do some of those things in the event that they're going into a nursing home, but usually it's too late to start doing that. I have other webinars and white papers on our website that specifically address nursing home protection that you should look at if you're interested in that subject. But again, people that should pass on creating a trust, if most, if not all of your assets are held in a retirement account, then creating a trust is probably not going to do a whole lot for you. Good. I'm going to open it up to questions in a second. We're about 40 minutes in. I just want to reference a couple of webinars that we have that are up and coming. September 26th, we've got guest speaker Brian Lynch from Lynch Insurance Group, who's going to be talking about Medicare benefits. The following month, on October 29th, we got Chris Gauthier, who's going to be giving us a quarterly update on the markets. In November, we've got essential strategies for a successful retirement. One of the things that I'll just point out, if you go to our website, let alone Amanda usually puts these things right on our homepage, just like you're seeing here. So if you're to click on this, then you'd get to see the white paper or the webinar. If you want to sign up for the September one, you click here just like you subscribe to this one, and you'll be receiving notifications as we get closer to the event to remind you that we're holding the webinar. We're also putting the white paper that I wrote for this presentation also on our website. I believe that is under right here, white papers. So when you click on this, to trust or not, you can click here and you'll see the document that I wrote that coincides with these slides. And it's a great way to, if you want to share something with somebody or somebody asks, hey, I don't know if I should have a trust. Well, somebody I know wrote an article about this. He's been dealing with trusts for 18 years, clients that have trusts. And he wrote an article talking about whether people should have a trust or not and things to consider. Let's go back. All right, so the next section is questions and answers. So what I'd like to do is, Amanda, if you received any questions during the presentation, if you could read those out aloud, and I'll do my best to answer them.
Hi, Jamie. Thanks so much. Just a housekeeping item. Again, if you do have a question, please just use the question taskbar in your GoToMeeting section, and we'll do our best to get to that today. We do have a couple here. The first one I have is an estate the same as a trust?
Yeah, an estate, I usually call it an estate plan. An estate plan is just how do you want your assets to be handled in the event that you become incapacitated or die. And you can do that with a will, a power of attorney, a trust. So a trust is just one of the tools that we use within an entire estate plan.
The second question I have here is there a site showing probate costs, for example, assets at $2 million?
Can you read that one more time?
Sure. Is there a site, or I presume a website, showing probate costs, for example, assets of $2 million?
That's a good question. You know, I don't know that. And I don't know, they could give you probably, you know, probate, what we're dealing with is the attorney's fees to help you probate the asset. And let's think of it this way. What if the asset is a business and they're trying to find new owners? Did they have a buy-sell agreement with somebody else who's going to come in and buy the company from the decedent? How do they value that corporation or that business? There's going to be a heck of a lot more work that an attorney needs to do to probate that business that's going through the estate than if somebody just has money at the bank that's got $2 million in it and they didn't name a beneficiary and they need to read the will and find out that they are leaving the money to their niece and nephew. That's not going to cost as much. I've heard horror stories, and I've actually seen estates that have run bills up to $40,000, $50,000. I haven't heard that in a long time. So I typically, in my mind, I think of, you know, $5,000 to $10,000 to settle an estate plan. But again, it really depends on the complexity of the assets and how hard it is to distribute those to the beneficiaries. So there's a lot of, it's really what you're going to end up paying is attorneys. Some of it's filing fees, I'm sure, but I think the majority of that fee is going to be billable hourly rates for having an attorney or a paralegal fill things out and probate the estate.
The next question I have is, I used to live in Mass, where we had estate tax sensitive trusts created. We have since moved to New Hampshire. Do we still need those trusts?
Yeah, that's a good question, and why I actually see this often. There are pros and cons. So when you incorporate trusts in your estate plan, especially estate tax sensitive trusts, they will pursue multiple. They have multiple benefits. Even though we're doing an estate sensitive trust, it also avoids probate. It's also a private process. So there are still valid reasons to create a trust. To have estate tax sensitive trust in New Hampshire that does not have an estate tax, and if don't have exposure to federal estate taxes because your assets are below $11 million, then yeah, I think I'd be more inclined to unravel the estate tax sensitive trust and maybe just pursue standard revocable trusts that don't even address estate taxes. And there's been some changes in the laws with portability, so that it used to be that in order to shelter the exemption, and I know this is complicated, but when you're dealing with husband and wives, if I pass away, the reason these trusts, the estate tax sensitive trusts are so effective is because if I pass away, they put $1 million into an irrevocable trust that my spouse can get access to if she needs to, but she'd be more inclined to leave it alone because that $1 million is not going to be included in her estate when she passes away, which is when the estate tax is going to be owed. So again, we don't want to do a lot of that stuff if we're not trying to deal with estate tax sensitive issues in New Hampshire for somebody that lives in New Hampshire. So I think I'd have a slight leaning towards unraveling the trusts and not incorporating those. There are a whole bunch of, there are other things like step up and cost basis issues that also favor not doing estate tax sensitive trusts. Again, if you're in Mass, I still think doing estate tax sensitive trusts usually prevails. In most situations it prevails, but in New Hampshire or a state that doesn't have estate tax issues, then I would lean a little bit more towards the not incorporating estate tax sensitive trusts and maybe not even using trusts, because if I just want to leave everything to my spouse and then maybe the children, I could accomplish that all through beneficiary designations and joint ownership with my spouse. If I want it to stay private, then just do simple trust, simple revocable trusts, and those should suffice. But again, I'm not an attorney. The best advice is go see a New Hampshire attorney and have that discussion. Let them look at your estate plan and find out from them the pros and cons and find out which one makes sense to you.
Jamie, we have a question here that says, my father passed away and left assets to my stepmother. It is my understanding that my sister and I will inherit these assets when my stepmother passes away. However, is it possible that she disinherits us?
Yeah. Well, that's going to depend upon the type of trust that your father put together. I think, where did I put it? It was, I thought I wrote somewhere, I thought I put in QTip Trust, but there is a, here they are, is a trust right for you. So if you have a more colorful family dynamic, so again, you know, second marriages is a classic example here, where there's children from a prior marriage. So if your father incorporated a QTip trust and that's what owns the asset, then that is an irrevocable trust. It cannot be, the terms cannot be changed. So if your father named you and your sister, I'm presuming your sister was from that prior marriage as well, then the terms of that trust cannot be changed. So your stepmother can get income if she needs it. She could probably even get access to principal, but I'm not 100% sure of that. But I know that that she could get income from this, and she would not be able to change the beneficiaries that your father listed. Now, if she received another type of trust and she's just the new trustee and it's a revocable trust, then she can change the terms anytime she wants. She can change the beneficiaries. That's also a risk if you do this outside of a trust document. This is why as soon as an attorney hears that there's a more colorful family dynamic, they will look at opportunities to incorporate irrevocable things like QTip trusts that say, okay, I want my new spouse to have access to some of this money, but I ultimately don't want her to be able to disinherit my children, and I want it to flow back. So you really need to find out if those assets are owned by a QTip. If they're not owned by a QTip, then I think there's a greater likelihood that she could change the terms and disinherit you, unfortunately.
In respect for everyone's time, I think I'm just going to go with one more question and we can get to everybody else's questions privately, separately after the webinar. The last question is, how much can a trust save us in Massachusetts estate taxes?
Yeah, so I typically quote about $50,000 to $100,000. So that's the typical range. Again, it depends on the circumstances and the net worth or size of the estate. But the typical savings, if you incorporate estate tax sensitive trusts, is around $50,000 to $100,000, and the cost to create these trusts is around $3,500 to $5,000. But also recognize that there will be additional costs after you pass away, because administering these estate tax sensitive trusts many times requires filing taxes. You may have to hire an attorney to do some things. So along the way, there will still be some expenses. Whether they add up to $50,000 to $100,000, probably not. So this is why many times people incorporate and go forward with creating in Massachusetts or other states that have death taxes or estate tax exposure, the estate tax sensitive trusts still make sense. And I would say 50 to 100 is probably a good number.
Jamie, I think that's it for today. Thank you so much for all of this information.
All right, excellent. Thank you, Amanda. Thank you, everybody, for attending. If you have any questions, you should know how to reach me. Call our telephone number, 978-624-3000, or you can always email me privately. My website and contact information is right on our website. Hope everybody has a great day. Take care.